Good morning, Aida ma'am. Video.
சரி. வந்துட்டாங்களாமா?
வந்துட்டாங்க சார். ஆரம்பிக்கலாம் சார். ஓகேங்க சார். தேங்க்யூ சார். Good morning to all. I welcome everyone Thank you for joining us for today's webinar. It's a glorious moment to extend my warm wishes on behalf of PSG College of Pharmacy. Today we will be discussing in the webinar on the topic intellectual property rights, patent filing procedures with three different angles. Intellectual property rights refers to the legal rights given to the inventor or creator to protect his inventions or creations for a certain period of time. These legal rights confer an exclusive rights to the inventor, creator, or his assignee to fully utilize his invention creations for a given period of time. With the ever-changing technology and shrinking word boundaries, the term intellectual property is coming to be used more often than even. The protection of intellectual property is important in the face of the fact that it promotes competition and development. Companies spend huge sum of money to develop new technologies with the aim of scoring some edge over their competitors. Intellectual property protection is critical to fostering innovations. Without protection of ideas, business and individuals would not reap the full benefits of their inventions and would focus less on research and development. In this aspect, we designed this one-day seminar with the objective to disseminating awareness about the IPR among various stakeholders and also to develop academic and industrial research perspectives. This seminar guides the researchers in respect of patenting their inventions and to provide insight into practical applications of patent drafting and filing procedures. It provides valuable information and interesting overview about the intellectual property in the industries as commercial and marketing tools in the global marketing. It will provide better knowledge about how to apply and what are the procedures for our time today. We hope you feel more comfortable and confident about IPR filing procedures. I want to convey my heartfelt welcome to all the participants with a smile. Have a nice day. Now we will start our program with a welcome address. To welcome all our speakers, delegates, I invite Dr. S. Maladi, Associate Professor, Department of Pharmaceutical Chemistry, to deliver the welcome address.
Very good morning to everyone present here. With warm greetings, it gives me a great pleasure to extend a warm welcome on behalf of PSG College of Pharmacy, conducting one-day seminar on IPR patent filing procedures. Now, I welcome our first speaker, Mrs. Bessie Titus, IP Manager at SET IMST TI Met Trivandrum. She is going to deliver a speech on sensitization on IPR. I welcome you, ma'am. The second speaker is Dr. Habibur Rahman, Professor, Department of Pharmaceutics, PSG College of Pharmacy. He is going to deliver a speech on patent procedure, Indian perspectives. I welcome you, sir. The third speaker is Mr. C. Arthur Paul, Senior Manager, Apex Laboratories, Chennai, is going to deliver a speech on IPR industrial perspectives. I welcome you, sir. I wish to thank all the speakers for accepting our invitation. I warmly and respectfully welcome our principal, Dr. M. Ramanathan sir, who has been the pillar behind this seminar. I extend my welcome to all faculties, students, participants who are all gathered here to add radiance to this occasion. Once again, I welcome you all. Thank you. Have a good day. Now I welcome our principal, Dr. M. Ramanathan sir, to deliver the presidential address.
Thank you, Dr. Malati and Dr. Aida Christie. So good morning, dear members and speakers and all the delegates and students of PSG. It's my pleasure to give my presidential address on the second topic on this IPR. Initially, we had a same one-day workshop, one-day seminar on this IPR. So where we invited industrial people and emphasized about the why we should go for it, what is its importance and everything. So once if we understand that their importance and significance, we should know the protocol, because what we think is a very lengthy procedures. It involves a lot of money and it takes a lot of time, and where to apply, how to apply. If we understand that they're responsible for this particular IPR, things may not many people have doubts, or even when we had our own molecule, when you want to go for patent for this particular IPR. Echo adu parunga, somewhere it is getting echo. So even when we had our own molecule, when you want to go for patent for this particular IPR. Echo adu parunga, somewhere it is getting echo. So even we had our own molecule. Is it okay now?
Yes, sir, it's fine. You can proceed.
Okay. So now, even when we had a molecule to go for patent, which we got it recently, so we approached the agent. So he is a person who did all our work, and then even if we take PSG Tech, we have a separate consultancy people who do this job for patenting our innovations. So this is an next step forward, because what I feel is when you have something in your hand and when you want to do a proper patenting and get your, it's like a publication. So where you want to get, what to say, your references to be done, and where you want to get some mileage out of it. So this is a better platform where you can learn. So what are the things has to be done? So when we drafted first with the people, they asked so many questions while filling the application forms. That is a very good experience for me and my colleagues who have done that job. When we did the first filling the applications, when we submit the IPR form in Chennai. So now this protocol, these three speakers, I really feel that it will give a very clear clarity about how, when you have something on your hand, how we can go further and how we can submit your applications in the respective places, in the respective office, and how much time it takes to follow up and everything. And what is the college level, institutional level, individual level application form submissions also might help you to know whether you want to go for through institution or through individual or through an industry. So how it can differ from place to place, from application to application. So this knowledge will gain you something it's worthful to learn. Now, apart from this, please understand the delegate, those who are juniors, the students. So if somebody is interested in drafting and applying and documentation, if you are very strong, like regulatory affairs, this is another area where you can think it of your career also. That is also another area where you can think it of, where you can see the most of the people have a basic degree, like the professional degree, and then they learned this IPR, and then they started in the industry, they got employed in the industry and started doing this patenting application submissions and getting it done from the patenting office. So those who are really interested, try to learn, because the drafting is one of the art, like paper writing is one of the art when you want to do an IPR. Drafting is one of the art. Try to learn those aspects also in this one-day seminar. And those who are interested, try to take it as a career of your future and try to learn and as a course, a separate course which are available at Indian level. If you want to go to international level also, it's available. Try to learn that particular program or particular course and take as your career. So my feel is by attending this one-day seminar, one-day conference, this one-day workshop will help you to know what is the protocol to be followed, how it has to be done, and what can be is doable within our limit, and also whether if you are interested, whether you can take it as your career or not. So with this note, I welcome again the three speakers, Dr. Raja Krishna Rajan, Dr. Habibur Rahman, and Mr. C. Arthur Paul for this, those who are going to deliver their talk in the next 3 sessions. And I'm confident that this event will give you, enlighten you the aspects of IPR. Also, I appreciate the Ida Christie and his team and her team for organizing this one-day event. Have a wonderful day, wonderful sessions, 3 sessions, and try to learn. And what are the effort which you have taken it has to reach you people, because it has been done exclusively for you people. So once if you are comfortable, and that will be our happiness. So with this few words, I conclude my presidential address. Over to the organizers to start the session. Thank you one and all.
Thank you, sir, for your kind words. So today, the morning session starts with the speaker, Mrs. Bessie Titus. Mrs. Bessie Titus completed her BTech in Biomedical Engineering from Calicut University and MTech in Biomedical Instrumentation from Karunya University. She worked as an assistant professor in Shraddha College of Engineering and Technology, Thrissur, from 2011 to 16. And currently, she's working as IP manager at SCT IMST Trivandrum. To her credits, she has undergone training in intellectual property rights under Women's Scientist Scheme of Department of Science and Technology, Government of India. She has been awarded the domain certificate from NPTEL on patents and intellectual property rights for the excellent performance in the various IP-related course examination. She also been elected as a member of the team by NPTEL to attend the Digital India program organized by Ministry of Electronics and Informational Technology, MeitY, Government of India, wherein she got the opportunity to interact with the Prime Minister office. She also published papers related to IPR in reputed journals. Her area of interest includes intellectual property law and its management. With this note, I welcome Mrs. Bessie Titus. Madam, please start your presentation. Thank you.
Am I audible?
Audible, ma'am. You're audible.
Am I I'm extremely happy to be with you all and share a few insights on sensitization of intellectual property rights. So moving on to the session, can you please share the screen so that I can show my PPT?
Sure.
I'm sorry, I'm unable to share my screen.
Yeah,
I
sure,
have actually.
we have, ma'am. We'll 1 minute. I'll share it.
Okay.
Madam, please wait for a minute. We'll share it out.
Okay, sure.
Hello, hello, madam. Can you?
Yeah, I can see it. Thank you. Thank you
Okay,
so
madam.
much.
Okay.
Can you please put it in full screen?
Okay, madam. Okay, okay. Okay, madam. Can you see that?
Yeah, I
Okay,
can.
madam. Thank you.
Okay, so I'm extremely sorry for the technical glitch. I'm sorry the participants have been waiting for some time. So before starting the session, may I know, is it only the faculties or the students are also involved in the session? Hello? Can you hear me?
Okay, ma'am. Okay.
Can you hear me?
Okay, ma'am. Okay, okay.
Okay, is it the students or faculties and students, a mixture?
That's a mixture, madam. Faculty, students.
Okay. No issues. Okay, thank you. So let's start with our presentation. Next slide, please. Next slide, please.
Okay, madam. Okay. This is second slide, madam.
Actually, it's still in the first slide over here. I can see only the first slide.
Okay, madam.
Yeah, now I can see. So the slide is not visible now.
Madam, please.
Yeah, okay, then we'll proceed like this. No need to make it full screen. Okay, so see, this is a famous quote by Barack Obama. He says that the future belongs to young people with education and an imagination to create. So I believe that in this present era of modern world, people are all educated and they are developing new inventions with their imaginations. The imagination of the students in colleges, in academic institutions is so much that they keep developing so much new inventions. So we should not stop them from developing the new invention. It should be brought for protection. Simply creating or developing an invention will not do any good. We have to go for protecting it, and it should be put into the market. Only then the society will benefit out of it. Next slide, please. Now, what is IPR? IPR is, as you all know, it is intellectual property rights. Now, what is intellectual property? Intellectual property is nothing but creations of human intellect or creations of human mind. A person, an educated person, will keep thinking of what solution he can bring to a particular problem, and that solution of his own creativity or of his own idea is what is called as intellectual property. And that property belongs to that so-called particular person, and it should be protected. And that is why the government is giving protection in the form of patent. Now, the right of that particular invention to that particular person is called as intellectual property right. Now, this, as we all know, any property, it can be tangible and intangible. Now, what do you mean by tangible property? Tangible property means it is something which can be seen, felt with our hand. We can see and feel it. So such examples are, you have a car or you have a building of your own and all those properties in your name. So all these material properties you will be having, which is registered, say, for example, a car. You're planning to buy a new car. That particular car, you will be registering it in your name. And then that registration, after that registration, that car belongs to you. So you have a legal document for stating that this car belongs to me. And so this is a tangible property. Just like that, you have something in intellectual property, which is called as intangible. Intangible is something which you cannot touch and feel, but it is developed in the human intellect or in the minds of the people. And that creation should be laid in the form of invention is where you go for patents. Not only patents, there are different types of IPR. So one of the most commonly used or one of the most commonly used intellectual property by people is patents. Next slide, please. Now, this, can you see the image properly? Audience, please respond. Anyone among the audience? This is one type of IPR where you are familiar with all these symbols or icons. I'm sure you're familiar with the Coca-Cola symbol, the Apple symbol, Samsung symbol. All these are available. All these companies' products are available in the market. Can you please at least guess what type of IPR is this? Anyone?
Trademark only, ma'am.
Sorry, I didn't hear you.
Trademark. It's a trademark, no?
Yes, absolutely. Correct. This is trademark. So trademark means okay. So this slide depicts the trademark. This slide depicts the trademark which is available in the market. So see, all these symbols or logos that is developed by a company, and it is the products of those company are brought into the market to distinguish it from another company. So that is what is called as trademark. So this trademark symbol is unique. It is unique to that particular company itself. And this particular brand, you say that symbol or logo, you call it as brand, and that company's brand product, you will purchase it because of the trust. That is, suppose if I'm going to buy shoes of Reebok company shoes, I'll go and I ask the shopkeeper to give me Reebok company shoes. Why? Because I have a trust that that particular shoes will will last for longer and it suits me well. So similarly, that trust which is developed among the people is because of the trademark. So, and this trademark is simply imprinted in the minds of the people, simply by seeing a symbol or a logo or the font in which it is written. You can simply identify which company's logo or design is it. So that is this trademark is one important aspect of intellectual property, and the term of trademark is 15 years, where you can renew it indefinitely for 5 years time period. So this is first type of IPR. Next slide, please. Now, next one. Can anyone guess what is this? Actually, I have not put the title for these different types of IPR simply because I just wanted the audience to identify what is it.
Ma'am, landmark. Is it location? It's location, no?
Yeah, it is location. So it is simply the geographical indication. We have another type of IPR, IP, which is geographical indication, which shows that this the products or the inventions that is developed from that particular geographical zone. Say, if you take towards Kerala, you can see this Aramula Kannadi. It is developed in Kerala, and this particular Aramula Kannadi, this is having the geographical features of that particular place, and it can be developed only in the place called Aramula in Kerala. Similarly, if you move on, you can see Kanchipuram silk, which is developed from Tamil Nadu. So there's a place called Kanchipuram, and people over there are weaving silk, and that is being brought to the market. So you cannot take a product which is developed in Kanchipuram and say it is developed in some other place and say it is Kanchipuram silk. Always make sure this particular product which is developed, it belongs to that particular place, and that is why the name has been given with the place name. So this is Kanchipuram silk. Again, you have Salem fabric. Again, you have Pochampalli Ikat, which is developed from Andhra Pradesh. So all these, you can say that all the geographical source has been mentioned along with the product. So you have Darjeeling tea, which shows that the tea is developed from Darjeeling. So that is the unique identity which is given to that particular product because it is developed from the place called Darjeeling, and the people in Darjeeling are involved in making it. So it is the exclusive right of that the people living in Darjeeling to develop the tea. I cannot make this Darjeeling tea in Kerala and say that this is a tea which is produced from Darjeeling. That is again offensive, and I have to pay for it. So this is another intellectual property which is called as geographical indication. I believe these two is clear to you. If at all you have any doubts, please make sure that you can ask it at any point of time. Next slide, please. Yeah. Now, this one you can see, there is literary work, musical work, artistic work, dramatic recordings. See, all these belongs to a term called as copyright. Now, copyright is nothing but, yes, I have received a message from Shaktivel. Yeah, you're absolutely right. This is copyright. Yeah, this copyright is nothing but, it is a form of expression which a person ought to do. A form of expression. Suppose if I'm a writer, I'm writing a poem or a story. So based on the creativity that I have, I will be expressing my views. Or supposing I am doing a drama, based on the creativity that I have, I will be doing it. Or if I'm a painter or a musical composer. So depending on the creativity, I have a unique method of expressing my views, and that protection, what the government gives, is called as copyright. Copyright, again, the term of copyright is the lifetime of the person plus 50 years. That is the time span that Indian government gives to the inventors of copyright. So copyright can be any form of expression. It can be even dancing, even singing or musical composing, whatever form of expression which is uniquely of a person, which is unique to that particular person, falls under the category of copyright. Next slide, please. Okay, now this is industrial design. Now, what do you mean by industrial design? Design, as the word says, is the appearance of any object with your eyes, or the ornamental aspect of any object with your naked eye. So you can see the products which is being developed in the market are having different designs, and some people, depending on the design, they change their form. Similarly, the different products that we like, some people choose the products depending on the design. Why? Because it is appealing to their eye. So this design is also an intellectual property which the government gives protection for a term of 10 years, which is again renewable for 5 years. So total 15 years lifespan you have for industrial design. Next slide, please. Now, this is a semiconductor layout. That is, in all engineering applications, you have circuit boards. So this circuit itself, designing of the circuit PCB is depending on the creativity of the person again. So government is again giving protection for semiconductor layout, and this falls under another category of IPR. Next slide, please. Now, you might be wondering, what is this? Now, this falls under the category of plant farmers' right and plant breeders' right. This is again, the government is simply giving protection to the farmers to develop hybrid varieties of agricultural products. So again, they also should get some protection because they are also working on it. So they can apply, farmers, breeders, then different agricultural people involved in agricultural products, they can apply for this particular intellectual property, which is plant variety and farmers' right. Next slide, please. Yeah, now this is, can anyone tell me what form of IP falls under this? It's just a cartoon character. If you can read it and tell me, just a guesswork. Okay, I'll just say, see, another form of IP is patents. Now, what is patent? Patent is an exclusive right which is granted by the government to the inventor for developing an invention. So this particular right, which is given to the inventor for developing the invention, and the invention which falls under this patent will have a functionality. That means the invention which is developed can be a product or a process, and it can be a solution to an existing problem. So many problems we find in our everyday life. Simple problems. How can you find solution to it? So developing a solution in the form of a product or a process is forming again another form of intellectual property, and it is named as patents. So here in this cartoon, you can see there is a person who develops a new invention, and always keep in mind that when you develop an invention, make sure that you go file and patent first and foremost. Only then you should disclose it to other people. Why? Because it is highly competitive. The world is very highly competitive. People may try to duplicate your product and sell it in the market. So if at all, knowingly or unknowingly, if you say to some of your colleagues or anyone, if you share your invention to anyone, they may duplicate it, and then you may lose your chance to file a patent. So always, if you have an invention, if you have a new invention, or if you have a solution to an existing problem in the form of a product or a process, make sure you go and file a provisional patent, and then you can disclose it to the society. If you file a provisional patent, you are in the safe zone. Then whatever happens, you are always in the safe zone. You will get the priority. Now, in this cartoon, you can see that there's a person who have developed his own new invention, and he tells to his friend that, see, I have my own new invention. And the other person is also saying, oh, it looks like mine. And now what happens? Both of them have disclosed their inventions, and nobody can file it. And finally, they go and put it in the waste. So it is simply being discarded just because they have disclosed it. Now, next slide, please. Now, you might be wondering, what is this? The last form of IP is trade secret. So, as the name suggests, trade secret is always a secret, which is kept as a secret between the employer and the employees. The most common example that we all know is KFC. Do we know the recipe of this KFC? No. This is because the recipe of the KFC is kept as a trade secret from years and years. Only those people who are involved in producing this particular product is obliged, will be knowing how to prepare this based on the secret that has been shared among that close group. And this is what is called as trade secret. Now, trade secret can be anything. It need not be recipes alone. It can be a formula, or it can be a business methodology. As long as you're getting an economic revenue from that particular secret, you can keep that particular product or that particular formula or that method as a trade secret. So that one example is KFC. Again, you have another example, which is Coca-Cola. So these are some examples which falls under the trade secret. So I believe we have discussed the types of IPR, which are categorized into 8 of them, which is, first we discussed about trademarks, then we went to geographical indications, then we move on to copyrights, then we move on to plant variety and farmer's right, then semiconductor layout design, then industrial design, then we have patents, and then we have trade secret. Is this clear? Any clarifications till now? Anybody please respond? Can I continue?
Yes, ma'am.
Okay, thank you. Okay, next slide, please. Yeah, next is what is discovery and invention? Can anyone tell me what is discovery and invention? Now, discovery is, you can see the first image, a person with a magnifying glass. That is, there was a particular product already being developed by somebody else, and this particular person simply saw it, or he discovered it that there is a product. That is, he has not put in any efforts and he has not put in any of his creativity. So that is discovery. Now, what is invention? Invention is the second person over here. You can see the second person is applying his intellectual thoughts and bringing out a solution to an existing problem. So he is using his creativity to develop a product or a process. So that is what is called as invention. So you can say that invention is nothing but it is a product or a process which is new and has a solution to the existing problem, and it has an industrial application. So that is the difference between discovery and invention. Discovery is anyone can discover anything. That is, the product was already there, but I simply found out that the product is there. I'm not using my intellectual creativity over there. But invention is something that I'm using my intellectual creativity and developing a product out of that. That is what is called as invention. Next slide, please. Now, let's move on to what I have received a message. Discovery, Columbus discovered America versus invention, Graham Bell invented phone. Absolutely right. Yes, that is Columbus discovered America. America was there before itself. It's just that Columbus came that way and he had discovered it. And Graham Bell, he is the one who has invented the phone. Okay, now moving on to the next slide, that is criteria of patentability. Now, so far what we have seen is what is IPR, what are the types of IPR, what is the difference between discovery and invention. So suppose I have a product, that is, I have used my intellectual levels and I have created a product. Now, I should be knowing whether it is eligible for apply for patentability. Because the government, not only Indian government, all over the world, they have kept a criteria for patentability, which is 1, patents should be related to a process or product or both. Second one is it should be novel. Novel means it should be new. The product must be new. Product or process, whatever you have developed, it should be new. Next one is it should have an inventive step or it should follow non-obviousness. And third one is it should be capable of industrial application. Now we'll discuss in detail what are the conditions, what does these conditions mean. Next slide, please. Yeah, now novelty. Now, novelty means the invention must be new. What do you mean by new? That is, it has been developed solely by the owner and it is not published anywhere in India or across the world, or any prior knowledge related to that invention is not there in public use. So then only we can say a product is new. Otherwise, we cannot say that that product is new. It can be a small change, or maybe you have developed a product, but an additional feature you are developing to that product based on your own creativity can fall under the criteria of this patentability. Only thing, you have to show that it is novel, it is not available anywhere else in the world, and the prior public with respect to this particular additional feature is not available. So it satisfies the criteria of novelty. Now, how can we know this product is novel or not? For that, we have something called as prior art. Now, prior art is any form of evidence that is available with respect to this particular invention. That is what is called as prior art. So usually what happens is that when we submit an application to the patent office, they check these criteria. If the invention satisfies novelty, inventive step, and industrial application. So for checking novelty, they will be checking prior art. Now, prior art, it can be anything which is related to your invention in the form of journals, in the form of paper publications, in the form of newspaper cuttings, or in the form of different other patents, or in the form of books, or in the form, or it can simply be a mere oral talk with another person. Any form of evidence will fall under the prior art. And if the patent office finds that your invention has a prior art with respect to this particular invention, then the novelty criteria will not be satisfied, and they raise an objection on novelty. So always make sure that your invention is novel. Now, next slide, please. Now, next criteria is inventive step. So what do you mean by inventive step? Inventive step is, as it is mentioned in the slide, a feature of an invention that involves technical advancement as compared to the existing knowledge. So, see, suppose I have a product, and a product might not be completely efficient. So what I do, I give my add-ons, or I use my creativity and intellect and develop a solution to have more efficiency. So that technical advancement as compared to the existing knowledge is what is inventive step. And again, you can apply for patent, but this is simply on the discretion of the controller. That is, you have an economic significance for your product. So basically, they check inventive step is depending on the technical advancement as compared to the existing knowledge. So there should be some form of technical advancement, not merely mosaicing. You have ample information out in the society. So mosaicing means taking one piece of data or one piece of technical information from one paper, then another piece of information from some other source, then third information from somewhere else, and then simply mosaicing everything and simply saying that I have a technical advancement to the existing knowledge. No, that again, the patent office will reject it. They will raise objection for that. So it should be merely your it should be. Can you hear me?
Yes, ma'am. Okay.
So it should be merely your own creativity for finding a solution to the existing problem. Next slide, please. Now, in the previous slide, I have mentioned that along with inventive step, you can have non-obviousness also as the criteria. Now, what do you mean by non-obviousness? Non-obviousness is, supposing, let's take an example. There are two people, A and B. Both of them are working in the same domain. Both of them have the same level of education expertise, and both of them are working in the same firm. Okay, so person A, he develops a product, or he develops an invention based on his own creativity and human intellect, and that particular invention is not obvious to the person B unless and until it is being disclosed by person A to B. Okay, let's take an example that water boils at 100 degrees Celsius. So that example, all of us know. If you say to another person, that person will say, yeah, it is obvious. We all know that water boils at 100 degrees Celsius. So what is the fact that makes it non-obvious? If we are adding something else and saying that the temperature has been brought down to say 96 or 98, something like that, or because of the addition of a third product or another product to that, and say that now the water boils at 98 degrees Celsius, then we can say that is simply the creativity of that particular person A, and it is non-obvious to the person B unless A discloses it to him. Otherwise, all the facts are obvious to everyone. So whatever you are developing, it is your own invention. And if it is a common fact, it is always obvious even to the external, even to the controller in the patent office. So there is no non-obviousness criteria falling there. But there should be some input or some value added initiative or value added intellect from your side. Only then it will be non-obvious to the other person. Next slide, please. Next is industrial application. Now, this goes without an explanation. We all know that any product that we develop, any invention that we develop, it should be capable of being made or used in any industry. Simply developing a product or simply developing an invention which does not have any industrial application will not benefit the society. Then why are you going to create it? Or why are you going, or what is the benefit that the society will gain out of your product? Let's take an example. You are say developing you are developing a pant or a modified type of pant, okay, and you say that it has 3 legs. Now, what purpose does it satisfy? It is not going to benefit the society, right? So such type of application, patent office will again reject it. So that is what is called as industrial application. So the main essential 3 criteria that has to be satisfied on applying for a patent application is it should be novel, it should have an it should have an inventive step, and it should have an industrial application. Most often what we find is that industrial application and novelty criteria is mostly satisfied, but that inventive step criteria is where the objection is being raised by the patent office. And it is solely the responsibility of the applicant to give his own reply for raising out that objection. And only when the controller or the examiner is convinced, depending on the reply filed by the applicant, only then he will move towards proceeding with the patent. If he is not satisfied with the reply given to the objection, your patent will be rejected. Next slide, please. Now, patent search. Now, so we have just discussed what is the criteria for patentability. Now, there I had said that novelty and inventive step is 2 major criteria where we find objections raised by the patent office. So what can we do for that? We have to do a patent search before filing a patent application by an applicant or an inventor. We should make sure that we do a patent search for our invention. Why do we do that? To find out if our invention is novel, if there is any patents or any form of evidence related to our invention. As I said before, the prior art. Prior art is nothing but the second line shows that any form of evidence that existed before filing a patent application. So anything related to our invention, is it already available in the market, or is it there in the form of journals, or is it there in the form of patents? All these things will be useful if we do a patent search. And finally, you can understand if your invention is patentable or not. Suppose you do this and you find out that your invention is not patentable. Now, what can you do for that? There, you have to channelize your invention. You should go through the different patents that are already available in the patent office website and which is closely related to your invention. You read those inventions and find out what you can make a difference with respect to the available patents. And again, as per those patents, you should channelize your invention and bring out some novelty in that. And then you can proceed for filing a patent. Otherwise, the objection will be raised, and it is simply that you're paying money and the patent is simply rejected. So that is why you need to do a patent search before filing a patent application. So it will save your money as well as it will save your time. So always make sure you do these patent search and then proceed with filing a patent application. Next slide, please. Yeah, this is what I said. Purpose of patent search: to determine how your invention is different from others. If it is same, your invention is already same with respect to another person's invention, then there is no purpose in applying for a patent. It will be rejected. And again, if it is very closely similar, then you have to identify, or you have to put in your thoughts and think, how can you channelize your invention and bring a technical advancement to the existing invention, which is already filed by the different person in a different patent. So that's where the application of patent search lies. So if you do a patent search, you can save time, you can save your money, and in due course, you will be able to channelize your invention and proceed further. Next slide, please. Now, so far what we have discussed is what inventions are patentable, what is IPR, what is the different types of IPR, then what is the criteria for patentability, and what is the purpose of patent search. Now, apart from these, there is something which is called as non-patentable inventions in India. Not all inventions in India will be given a patent. For example, frivolous invention or anything contrary to well-established laws. That is, I'm saying a perpetual machine, which gives 100% efficiency. Nowhere in the world we can find a machine which gives 100% efficiency. But I'm saying that I have developed a machine which gives me 100% efficiency. That is not patentable. And again, we all know that Newton's law, according to gravity, things fall down. We are saying that we have developed a product or a machine which makes things move up, but does not fall down. So it is again contrary to well-established laws. So you don't get patent for that. Then again, an invention which causes serious prejudice to plant or human life. Suppose I'm developing say product to cause to cause theft, or to cause robbery, or things like that, which is causing serious prejudice to man's life. That is not patentable. So you might be asking, can we take a patent for a gun? Yes, there is patent for gun. But there lies the tactics of writing a patent application. That is, when you draft an application, they have taken the patent for a gun, stating that I have a revolver, and when I strike that, it moves at this much degree forward, and then it comes back, and that is how it is written in the patent application. That is, you are showing that you are not showing that it is a gun, you are showing just that it is for a constructive application. So that is how people take patent for it. But simply for theft or for causing any adultery or if you are going to take, that is not possible. Now, again, mere discovery of scientific principle of formulation of an abstract theory. Now, scientific principle and abstract theories, this is already available. You are not doing anything of your own. Again, it is a discovery. So patents will not be granted for that. Next slide, please. Now, mere discovery of new form of known substance. I believe this particular criteria will be very useful for the pharmacy college students, because we find that basically you all deal with drugs, right? So these pharmaceutical products, what we find is that in this, it is said that mere discovery of new form of a known substance. That means the substance is already known and you're changing the form of it, and you're simply discovering it. Okay, so a new form of a known substance means I have a product, a drug which is available in liquid state, and I say that I have put it into a solid state and I go apply for patent, you will not get patent for that. Again, these drugs have it will be in a compound, or it will be in the form of family, right? So how people take patents for this drugs or pharmaceutical products is that they write claims or they protect for the entire family, so that the family of that compound, so that no other third person will infringe into their product in the next time. So again, the patent office has mentioned that new property of a known substance, already known substance, a substance which is known. If you're simply changing the form, you will not get patent. If you're simply saying that, yeah, I have discovered a new property now, till yesterday, you have not discovered. Today, you're saying that you have a new property. The property was already there within that substance yesterday also. It was just that you found out today. That is not, patent will not be granted for that. Again, a new use of a known substance. That is, I have a paracetamol. Okay, so and that paracetamol is being patented. Today, I say that this paracetamol can be used for solving the problems of gastric issues, but that will not be given patent. Why? Because the new use you're saying today, that was there before itself. You have not given any value added inputs for this. Already the products were there. The products as its own, it has some property and it is showing some property there. So because of that, you're getting an output. So suppose, how can you take patents for this pharmaceutical products? I can say that if you have, say, product A plus B plus C is equal to, say, E. Okay, so this E is already available pharmaceutical drug which is there in the market, and A and B and C is showing its own properties. It is having its own everything. Okay. And tomorrow I say that I have added D, A plus B plus C plus D, and again it is giving as E. So the patent office will be asking, see, already there is a patent for A plus B plus C is equal to E. And now you're coming and saying that you have added D, but the result is E itself. So what you need to do there is, you have to show patent office, you have to show experimental results stating that on addition of product D to A plus B plus C plus D, when you add it to these three compounds, A plus B plus C, you have given, you got an output, or you got a result E, which is having therapeutical efficacy more than the previous patent. When you had A plus B plus C, the result or the therapeutic efficacy at that point of time is less than when you add D, you have given, you got more therapeutic efficacy on addition of D. Only if you can prove that in the form of experimental evidences, then patent office will be giving you patent. Otherwise, under this non-patentable invention, this falls and you will not be granted patent. Let me state a remarkable case study based on this section 3D. We say it as section 3D. Now, there was a company which is called as Novartis. This Novartis is a company which is situated in Switzerland, and they are quite established, and their main products for pharmaceutical products and drugs, and they have applied patent in different parts of countries for different products, and they have developed a product which is called as imitinab mesylate. And this imitinab mesylate is a drug which is used for curing cancer. Now, this particular product, they have applied patent in different parts of the world, and nearly 35 patents they have granted. They have received for this particular product. But when they came to India, this particular company, when they came to India, so before that, please keep in mind that until 2005, until 1995, India was not accepting any pharmaceutical patent application and food patent application. India was not giving any patent for these pharmaceutical products and food products also. So in 1995, India signed an agreement which is called as TRIPS agreement, and under that agreement, India has asked for a transition period because on that, based on that agreement, they have to make changes in our Patent Act, Indian Patent Act. We had to make several changes. So India had asked for a transition period of 10 years from 1995 to 2005. They had asked for a transition period, and only after 2005 they started receiving or taking the application related to pharmaceutical products. So what happened? Meanwhile, this Novartis company, they came to India and they wanted to sell this product, this drug on imitinab mesylate, which is a cancer drug. So what they did, they filed a patent application. But I said they came in 1998. But we had a transition period from 1995 to 2005. So we had a special provision which is called as mailbox. So they have put their application in mailbox and it was kept there till 2005. Now in 2005, what happened is that when the patent office examined their application, they found out that this particular company has filed patent application for imitinab mesylate in different parts of the world. And when they came to India, they have filed a patent application for the beta crystalline version of imitinab mesylate. So see that the product is the same. Imitinab mesylate is the same. The form has been changed. Beta crystalline form is the highlight they have mentioned in their patent application. Otherwise, the rest, everything is same. So what happens there? The novelty of the invention is not there. Inventive step is not there, and it is not falling under the. It is falling under the non-patentable invention criteria, because it is simply a different form of the existing product. Beta crystalline version, they filed an application based on that, and it was rejected. They went to Supreme Court also. Supreme Court also said that because the imitinab mesylate version was there, which was filed in other countries, and it was granted, and they have not added anything value added to this patent application which is filed in India. Only thing, they have changed the form. The beta crystalline version of imitinab mesylate was mentioned there. So it will not be granted patent. It was a very landmark case. Until now, everyone, they look upon this section. When they look upon this section, they will remember this case. Okay, so next one is a mere admixture resulting only in the aggregation of properties. Again, people dealing with chemical and pharmaceutical products, admixture, you need to mix so many compounds. So here in this particular line, it says that mere admixture, that is, I'm taking a glass of water, I'm adding salt, say 1 spoon of salt and 1 spoon of sugar. But what I'm getting as a result there, I'm not getting any result there. Salt will show its taste, and sugar will show its taste. Am I getting a different product in this glass of water upon adding 1 spoon of salt and sugar? No. So simply admixture of different components will only result in the aggregation of properties. I'm not getting any new result based on this products which is added. So that is not patentable. Now, next one is mere arrangement or rearrangement or duplication of known devices. As I said before, you have a known device. You are arranging the positioning or rearranging the devices in your own way, and you are applying a patent for that. That is not granted. Suppose I have an umbrella, and to that umbrella, I'm taking an existing torch and attaching to that umbrella, and I'm fitting it over my forehead. What value addition have I done there? I have not added anything. Torch was available there. Umbrella was available with again over there. What I did, I just added two products together. Again, that will not be granted patent. Now, method of agriculture or horticulture. Now, we know that there are different methods which is being adopted. All those methods as such will not be granted patent. If you want to apply for, if you want to go for a protection in agriculture, you have a different aspect that I have mentioned earlier, which is plant variety and farmer's right. So under that you can go, but not for patent. Then any process for medicinal, surgical, curative, prophylactic, etc., or other treatment, that you cannot go for patent. That is simple example. Root canal treatment. The method of root canal is same. All doctors are following the same thing. You cannot take patent for that. Or when you go to the doctor, he or she will take the stethoscope and hear the heartbeat sound. That is not patentable. It is already known. It is a method which is for surgical, curative and all. But that process is not patentable. Next slide, please. I think you missed one slide. Yeah. Now, next criteria is plants and animals as a whole. I cannot patent a plant as such. I cannot patent an animal as such. So that is not patentable. Then a mathematical or business method or computer program per se. Now, mathematical or business method, if you are writing maths, you are depending on your creativity, you're writing the steps and you're following a method and you're giving an application for patent in the patent office, it is not patentable. Again, a computer program. I'm writing the logic or the coding for working a device, and I'm applying for this software coding. That algorithm will not get a patent. But you will get a protection for that if you apply on copyright, because that is the expression of a person, the way he writes the coding or the way he writes the mathematical method. And in that category, you can apply. That is copyright. Now, if you want a patent for a computer program as such, you have to show that you have a device and that device is working based on the program which is written by you. So you are taking a patent for that device, and the device functioning is based on the program that is written by you. Then you can apply for computer programming on the device. Then a literally dramatic musical or artistic work, that again falls under copyright. Then method of performing mental act or playing game. I'm playing caroms or I'm playing chess. You cannot patent that. Then presentation of information. The calendar that we have or the railway timings that we have, that is simply presentation of information. You cannot apply patent for that. It is not patentable. Then topography of integrated circuits. That is IC is another criteria where we have seen earlier, that is semiconductor layout. Under that protection, you can go, but not for patents. Then traditional knowledge. We all know that India is a land rich in traditional knowledge. We have our own products like turmeric, and turmeric is used for wound healing property. It is been actually our forefathers have advised us, if you use this, your wounds will be healed. So that is a traditional knowledge. That traditional knowledge, we have not added any value to it. It was already there. It has been passed generation to generation. So traditional knowledge cannot be patented. Again, last but not the least, that is invention related to atomic energy. Atomic energy, you cannot, inventions related to that, you cannot patent it because it is used purely for defense purpose. So that it cannot be taken. So these are some of the criteria where you cannot patent inventions. Next slide, please. Yeah, now who can apply for patent? it is three criteria is there. One is inventor. Inventor is the sole owner of the invention or assignee of the inventor. Inventor can assign his invention to somebody else, and that assignee can apply for patent. Then third one is legal representative of deceased applicant. So if a person has been expired, then the legal representative has all right to apply for patent. So these are the three criteria who can apply for patent. Now, next slide, please. Yeah. Now, this is simply an example that I wanted to show. This Coca-Cola company. See how much IP they have taken for a single product. You will be amazed to know that if you see in that right-hand side, the bottle of Coca-Cola has been shown, and they have taken patent for manufacturing the beverage. That is, as I said before, patent is solely for functionality of the product that can be process or product. And they have taken this patent for manufacturing of Coca-Cola, how they manufacture it. There will be a device for that and for that also. Now, the way they write Coca-Cola, it is a trademark. And the design of the bottle, again, it falls under another form of IP. Then copyright, that is the picture that is being shown. That falls under the copyright category. So see how much IP in one itself they have taken. And after taking IP, if they bring it to the market, how much money they can make it, because nobody else is allowed to duplicate it. They are the sole inventors or sole owners of this product. So they are having all right to, once they patent it, they are having all right to manufacture it, sell it, export it, whatever things they want to do with that particular product for a term of 20 years. The patent term is 20 years. So after 20 years, this product will be in public domain. You have no right to it. So this, what this Coca-Cola company has been done, see, it was being found in 1892, and nearly 6,893 patents have been filed in the name of Coca-Cola. See, single product, how many patents they have filed. So it might be a small change in the product or in the process, they file a patent. So that's how the market is, or that's how people in the market is, because only if they file patent or only if they protect their invention, they can put it in the market. Otherwise, there are a lot of competitors who are simply staying there to duplicate and put it in their name. Next slide, please. Can you, I don't know if you can see this. That is on the left-hand side, it is on, on the right-hand side, it is on the technology that they have adopted, or on what basis they have filed patent, or on what all aspects they have filed patent. And left-hand side, it is the different countries that they have filed patents. So if you can zoom it, I believe the audience can see it. Can you please zoom it? Is there any provisions? Okay, thank you. So see this on the left-hand side, it is patent filing worldwide. United States of America, you can see it is 1119. See, way back, coming back to India, 200 patents have been filed in the name of Coca-Cola. And on the right-hand side, this is the technology area where all they have filed patents. See, for beverage dispenser, they have so-and-so patents. For design, they have 287 patents. For beverage packaging, they have this much patents. For production line, this much patents. For vending machine, this much patents. So for each and every minute details, they are filing patents for that, to make sure that tomorrow nobody else will infringe their product. And once they file patent, they can put it in the market so that nobody will come and infringe it. Next slide, please. Now, this is a design registration, please. Yeah, thank you. See the design registration for, again, Coca-Cola. The bottle, it has been improvised again and again and again. Shape of the bottle and the glasses, first US design. See, in US, they say design patents. Okay, so first US design patents is in 1916 and it has been redesigned in 1923, 37, etc. So they are being, revised. They are revising again and again in terms of products, in terms of process, in terms of their design. Only then they can stand in the market. Next slide, please. Next, we have, see the trademark. As I said before, it is a sign or a logo or a symbol that is being shown by the company to distinguish their products from other. So see how Coca-Cola has been written in 1886 and then in 2007. They have changed their font, and again, finally, in 2007, they have come up with it. This is all simply to make you aware how the companies are showing their IP or how their products have been changed in coming years. Okay. Next slide, please. Now, this is trade secret. As I said before, how the beverage Coca-Cola has been manufactured, that trade secret is being shared only with a small group of people, and it has been written down. And that small group of people only know how this beverage has been manufactured. And it has been passed on from generation. And then that is how it is being kept as a trade secret. Next slide, please. Now, what I want to say is that, see, if you look around, anything and everything, you have an intellectual property there. The words we read, you have trademarks, the images that we see, you have different images. It can be, again, trademarks, or it can be copyrights, or it can be design. The videos that we watch, it can be copyrights, it can be the expression of a person. The music that we listen, it can be, again, copyrights. So everywhere, at each and everything that we look upon, there is an IP there. So what we have to do is, we simply should take the initiative to file an IP and then proceed further. So it's a natural tendency that when everything is free, we don't take the initiative. So that is what this famous quote is all about. Most of it is available to us for free, but free does not make it ours. Next slide, please. So we are coming to the end of the session. End of this talk. That is, I just wanted to say a few words regarding what I am doing in CTIMST TimeIt. See, we have a project which is being funded by BIRAC. And it is basically, the objective of that project is for technology transfer and intellectual property services. So which is focusing on academic institutions, research institutions all across Kerala and Tamil Nadu except Chennai. So what we do is basically I'm working as an IP manager there, and we file patents, we facilitate all requirements for academic institutions. We help them in drafting. We actually file patents for them. We do prior art search. Prior art search, as I said before filing a patent, we have to check if there are any inventions related to our invention. Then we do patent landscaping, that is finding out what are the competitors, who all are the competitors for this particular product. And then apart from these, we have technology transfer, that is we are trying to find out how can we transfer our invention to the market or put it in the market. So these are some of the objectives that we are looking upon at our office. So if at all, at any point of time, if you require any help, please don't hesitate to contact us. Next slide, please. Now, this is a video where I just wanted to show you what is the importance of IPR. So with this, we'll end. Please click on the video on the URL site. It is not. I think it's not being plain.
Click the control and press the link, no? The operator. Control the
Sorry?
control. Yeah, just a second, ma'am.
Okay.
Is it Ranjit is
Sure.
operating? So please click the control button. Along with that, you press the link, no? Control button in your system.
Okay, if it is not playing, no issues. Yeah, the first one. There's no. So see, this boy had already filed his invention. So infringers tried to come up with duplicate his invention and file a patent application, but that was not possible because boy had earlier gone and filed his invention. So it just shows the importance of IPR. So thank you so much. I hope this session was useful to everyone. So thank you all. If in case of any queries, you can ask me now, any doubts?
Participants, you can ask questions.
Are we running out of time? Is it time for the next session?
Yeah, we can have next 5 minutes, ma'am. We can have.
Okay.
Participants, please put up your questions if you have any.
So if you have any queries, if not now, if you have any other queries, you can mail to me. You can ask Ida ma'am for my mail ID. She's having it. So you can post your queries there also, no issues. I'll be replying to it. So or if you want to call and ask me also, there is no issues. At any point of time, I'll be clearing your doubts also. I hope I could transfer the essentials of IP to all of you.
Thank you, Mrs. Bessie Titus. It was so wonderful and interactive, and it should be very useful for the students and as well as for the faculty members those who have joined the seminar today. And once again, we thank behalf of PSG of College of Pharmacy for taking the short notice and making today's presentation as a good one. Thank you, Bessie Titus.
Thank you.
Thank you. So the next session will be resuming by within next 10 minutes. So then the next speaker will be Mr. Dr. Habibur Raghuvan sir, Professor, Department of Pharmaceutics. So we all can join by 11:55. Now the webinar is closed.
Sir, shall we start? Sir,
Yeah, yes, we can start.
please start, sir. So once again, after a small break, I welcome all the delegates for the session 2. And also I welcome our speaker, Dr. Habibur Rahman, Professor, Department of Pharmaceutics, PSG College of Pharmacy. Sir is going to deliver a speech on the title Patent Procedure, Indian Perspectives. I wish to introduce our speaker, Dr. S.M. Habibur Rahman, sir. So, sir started his pharmacy education from Diploma in Pharmacy at JSS College of Pharmacy, Ooty, and also B Pharmacy also in JSS College of Pharmacy, Ooty, and M Pharmacy in Pharmaceutics branch, College of Pharmacy, SRI PMS, Coimbatore, and also he did his PhD in JNDH Hyderabad. Also done certified radiological assistant course in KG Institute Paramedical Sciences, Coimbatore. Sir is working in PSG College of Pharmacy from September 2007 onwards. In between, he worked as assistant professor in FPS UCSI University, Malaysia from 2018 to 20. At present, sir is working as professor and in charge of research activities at PSG College of Pharmacy. Sir has guided 21 M Pharmacy projects, 23 B Pharmacy projects, and also guiding for PhD scholars, 3 scholars. Sir is having 38 publications in national and international journals, indexed journals, and sir has also presented papers in national and international conferences. Sir has received 12 research grants from different research projects from different funding bodies at around 70 lakhs as a principal investigator and co-investigator. And also he received 3 travel grants also. And sir has received 10 awards like especially Asian Youth Innovation Award, Gold Award, and Asian Youth Innovation Award, Silver Awards, and International Eminent Researcher Award, Honorable Jury Mention faculty category, the 8th Faculty Branding Award to 820. And also, sir received some Best Poster Presentation Awards, Best Oral Presentation Awards, like that. So, and sir is also in the member of professional association and with the different organizations. And with this, I invite our speaker, Habibur Rahman, sir. Sir.
Thanks, Professor Ida ma'am, for the very long and brief introduction about me. I thank the organizer. I'm also part of the PSG College of Pharmacy. It's my pleasure to share some of my thoughts on the patent processing Indian perspective on the one-day webinar organized by the NAC team and in collaboration with Anna University Entrepreneurship Cell. I hope the slides are visible to the participants. Is it visible to all?
Yes, sir.
Yeah.
Yes, sir.
Thank you for the confirmation. So just my previous speaker, Ms. Bessie Titus, has given a very brief introduction about what is property, IPR, and how it has been protected. And she has shared the experience and explained all the process by keeping some case studies like Novartis and how the company of Coca-Cola has keeping their product and the label and everything in the protected manner by giving out nearly 200 patents only in India and more than 100,000 patents in US. So she made my job easy. So mostly when we talk about the patent and processing, it is legally it is a law. So as an academic person, you may expect some of the boring slides with so many contents here. As we are dealing with the law, we have to mention the law. So there is no explanation about the concepts here. So the law is law, we cannot protect. So what I say generally, patent, when you're looking at patent, how closely you are reading the patent or the patent clause. It is going to make the difference in whether you are going to get a grant or not. So that's why as academic people, we study a lot of laws and we are planning for going for a patent. It means we have to sit and write, like in the presidential address, as our principals have mentioned. So how tough it is to have a drafting along with the patent attorney and patent analyst who is in their job. So we write papers, we write publications, we write some kind of research projects. When we are going for a patent, it is going to be more legally scrutinized, how it has been. So in between lines will be read by the patent office to scrutinize, like Ms. Bessie Titus has mentioned, the prior art. So we have to be very clear that what we are providing in our patent application process. So that is what we are going to discuss here in some of my slides too. So the first slide, we have to define what is the property, what the property I have and how I am going to attain the the legal right over that particular property. So it's any item or a person or a business. So you can go as a patent, as a legal right, as an individual or as a company. So it can be of a tangible and intangible, like movable properties, car, pen, or immovable land, building. When you come to intellectual property, means it can be of literally works, inventions, novel creation of what is the intellect. Human intellect is producing some kind of ideas that is going to be your intellect mind that becomes the property. So when you define or when you want to look at how the patent laws are defining the intellectual property, product or a creation of your mind. So it is a different form other than properties. It doesn't have any kind of a, your idea is not having any picture or it cannot be a material. So it is the creation of the mind. So it is intangible while compared to the other properties. So it needs some kind of a different way for its protection. So that is what intellectual property, how it can be that intellectual property, how it can be made as your right. So the IPR is the body of law developed to protect the creative people who have disclosed their invention. If I have a creative idea in my mind and I want to disclose that as an invention for the benefit of the humankind, then it can be protected through your IPR. So the invention being copied or imitated without their consent. So once you are protecting there, as like the previous speaker has shown that video where your idea has been already protected, so the other group cannot able to use it without these people's consent. So that is the intellectual property. So way back in 14th century, so when you look at the history of IPRs, so the Jonas Gutenberg, he is from Italy, who was the man who has initiated this patenting process. So IPR initially started in North Italy during the 14th century. Then Venice issued a law. So the Venice is the first law issued related to patent protection, which is exclusively providing the right for that particular inventor. He has invented a movable letters for printing. So it is a printing press with replaceable and movable wooden or metal letters. So this has created a look at how that particular patents or products can be protected and how the law can be made. So that is the first one. So, and this invention and the protection, the printing press has enormously improved the education of the society in the Euro population. Then late 19th century only. So after around 5-6 centuries, then the number of countries felt necessity of laying down a laws regulating IPR. So different countries have their own IPR. Then how the WIPO, World Intellectual Property Right, or World Trade Organization, how they have pooled and they made as a patent cooperative treaty. So initially the Paris Convention for the Protection of Industrial Property in 18th century, 1883, and Berne Convention. So this Paris Convention and Berne Convention, or the protection of literary and arts, becomes the Berne, and the Paris Convention is for industrial property. So these two treaties are very important in the development of many IPR laws in different countries. So how do we classify the IPR? So the intellectual property can be made as a patent, trademark, industrial design, then GI, as it all has been explained in a detailed manner in the previous session. So if you look at the copyright, then it can go for a work of arts or a literature, music, broadcasting, dramatic work, sound recording, computer program. These all become the copyrighted products. So we can separate the intellectual property, then copyright. So the copyright is the tangible, and intellectual property is become the intangible one. So what is the property you have? How we are going to achieve the right over the particular property? So that is intellectual property right. So the everywhere in the intellect will be your idea. So the property becomes whether the expression or innovation or quality and identity, appearance, and keep confidential, no disclosure. So like this, how the property is going to be. So if it is idea is going to be expressed, and that expression you want to protect means, then you have to go for a copyright. If you want to go for a innovation, it need the invention so that it can be used by the larger population. It can go into the commercial market. Then you can protect that particular property as a patent. Then idea is a quality one plus identity. So then you can go for, like Coca-Cola, you have to go for a trademark. Then appearance. So your logo will be appearance or a design work. Then you have to go for a design patent. Then trade secrets, like what is the secret recipe in Coca-Cola or KFC, that can be made as a trade secret. So this is the general outline of how your property or how your ideas can be protected. So if you look at this graph, just as we mentioned, in 14th century, the patent and patent law has been started, and different kind of World Trade Organization and treaties has been meant through the Venice and Paris conventions. So the first patent in US has been numbered in 1836. So over the period of nearly 200 years period, So they have reached 11 million patent numbers. So this is the way how the US has progressed in protecting their rights of their human intellects, how they are protecting so that it can safeguard the society for future use. So the patent word derived from Latin word again pateni, to open. So here nothing but if you have hold a patent, so that particular idea can be opened for the larger population or use of the humankind where it can lead to. So it is a grant of a monopoly right to an inventor. If I am an inventor, I am going to get a monopoly right over that particular product or process. Then I can use a skill to invent something new. So it is given to a patentee for an invention for a limited. Yes.
Sir,
Fine.
continue.
Yeah. Okay. So the patentee has been given as a patent for an invention for a limited term period. The term period will be usually 20 years. Then he can have the right to exclude others from using your invention. If I don't want anybody to use my inventions, I have the right, or I can give my consent to use it, or I can sell it the patent. So the owner of the patent has the qualified right to use that particular invention. What you mean by invention here is a new product or a process involving an inventive step, not obvious to a person skilled in the art. Like what are the criteria or crucial factors which you have to look at when you're going for a patent? So it should be a non-obviousness. So as already mentioned by the previous speakers, different things, what can be patented. So the non-obviousness is an important factor as an invention if you want to make and capable of an industrial application. So this is invention. So one more way of defining or how the World Intellectual Property Organization, WIPO, is stating patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. So it should be of a completely newness should be there in your idea or new technical solution to that particular problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So that's what you have an idea. If you want to go for disclosing that to the public, before disclosing it, you exclusively own that particular idea through the patent. So that is what it is all about. So in principle, what the patent owner has the exclusive right to prevent. What we are doing by having this particular patent with me, I am going to prevent the use of commercially exploiting my idea as a patent invention by the others. Patent protection means that invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. So anyway, that is going to be an infringement. So if you have a patent, then obviously people who is using your idea, then that is going to be the infringement. Then you can go for a case and you can win the case and you can get that particular damage what has been done to your product or idea. So that is how most of the patents work. If you have two competitors having a patents and they go for an infringement suit, then the legal fight will happen and they'll settle with the big amount of money for sharing their patents or the infringement what has been. Depends upon the case how it goes. So if you look at the patent, so here the complete timeline of the patent is important from the time of application to the time of expiry once you have patented. So there we have an act, then we have a rules. So the act is nothing but the broadly mention about what are the things related to that particular act. So here I am talking about only the Indian Patent Act. So the Patent Act will be having the broader divisions of how we are going to provide a patent and how you are going to make a law. Patent rules become the provisions inside the act. So the detailed provision under each section of the Patent Act will be given in the patent rules. So the Patent Act means it has to be passed through to both the houses of our country, the parliament, then it has to become a bill and then it can be enacted as an act. But patent rules doesn't need approval of parliamentary board. So it is going to be the internal changes. If you are having a patent act and you have a provisions that particular provisions is becoming a rules that can be amended as an internal factor within the union government. So this is what the act and rules difference. So it is way back in 1856, it has been started in India. So by the based on a British patent law of 1852, then certain exclusive privileges granted to inventors of new manufacturer for a period of 14 years. Initially in 1856, based on the British patent law, the exclusive right was given to the manufacturer for around 14 years. Then after 3 years period, the act has been modified and monopolies called exclusive privileges like making, selling and using invention in India and authorizing others to do so for 14 years from the data filing specification. So initially those periods there was only 14 years. Then the Patent and Design Protection Act came in 1872. The Protection of Invention Act came in 1883. So it has underwent a lot of deliberations with the different committees, then a lot of revisions, then how the TRIPS and WTO has been came into the picture like this. Many happenings would have been around those periods. Then 1882, these all the, I can say these all the evolution of the different patents and how the countries are protecting their human intellects idea, how they are selling it in the different countries like that. So consolidated the Invention and Design Act in 1880. Then 1911 was the Indian Patents and Design Act. So that was there for a longer period, the 1911 Act. So after many years in 1999 only the March Patents Amendment came into force. Then 2002, 2005 there was amendment in the Act. In patent rules has been created in 2003, amended in 2005 to 6. So here the Indian Patent Act was 1970. So that year has been not mentioned here. So between 1911 and 1999, so in the year of 1970, 1950s, the Rajagopal Iyengar committee was the first committee, has been created to look for what is 1911 Patent and Design Act of the Indian. So the committee reported in 1959 covering all the lapses of the 1953 bill. Then the report suggested to keep that particular Patent Act with major changes in the law formed on the basis of the introduction of the Patents Bill in 1965. So the first patent bill was initiated and introduced in the parliament in 1965. Anyhow, it has been not, in Lok Sabha, it has not passed. Again in 1967, it has been amended, was introduced, which was referred to a joint parliamentary committee. Then on the final recommendation of the committee, the Patent Act 1970 was passed. So it has underwent these many processes. Second time only it has went to joint parliamentary committee as a standing committee. Then they have given the final recommendation. Then in 1970, they passed the bill. So the act repealed and replaced in So this particular act, the 1917 Patent Act, completely replaced the 1917 the Patent and Design Act. So however, the 19 Act was continued to be applicable to the design. So only that kept as being only for designs not related to the other properties. Most of the previous provisions of the 1970 Act were brought into force on the 20th April 1972. After 2 years, it has been enacted in the publication of the patent rules in 1972. So this is the historical Patent Act and the different amendments what has been made. So here in patent rules has been changed from 2003 as we have entered into the World Trade Organization TRIPS agreement. Then the TRIPS agreement that time has been given for PCT application like Patent Cooperation Treaty agreement by the WIPO. One patent can be filed internationally. Then that particular single patent application can be claimed in different countries in their own country of origin. So these patent rules, the TRIPS, they have, the WTO has been given 10 years of transition period to make a compliance with all their TRIPS agreement rules. So that's why the patent rules has been revised many times from 2003, amended in 2005, again amended in 2006. Recently, they have amended in 2013. Again in 14, 16, like that, the patent rules are keep getting amendments in different senses, as it is an internal union government process where they can change the rules. It doesn't need to be passed as an act. So what is the patent law, or what is the salient features of this particular patent law? So it can be for both product and process. Both can be provided patent, and term of patent is 20 years, as I mentioned. Then you can ask for the examination on request. Then both pre-grant and post-grant opposition. So both the parties or already who is having a patent, if they feel that that particular new published patent is infringing your patent, they can you can go for pre-grant or post-grant opposition. Then fast-track mechanism for disposable of appeals. So you can fast-track the different what are the different appeals which is there in the patent appellate body, then Supreme Court, then High Court, like this different kind of a legal process is there to fast track that particular disposable of appeal. Then provision for protection of biodiversity and traditional knowledge. So protection of biodiversity and traditional knowledge. As we know that the curcumin, the turmeric, it has been came from the Indian Ayurveda. It is a color of life we used to mention. So that is going to be tried to patented by the US. It has been protected because of the traditional knowledge which came under the, it cannot be patented. So like this, the biodiversity of your country and the traditional knowledge based on your historic and the cultural things can be protected through the patent law. Then publication of application after 18 months with facility for early publication, then substantially reduced timelines. So these are the some of the patent lines where you are going for an amendment or changing the patent rules. These all going to be the salient features of your patent law. So again, these all points already has been discussed in the first session also. Just I will be brief on these slides. What can be patented? You need an inventive step. Something it has to be innovative, which is not previously discovered and disclosed to the public. Then new, it should be a new or a novel one. Like there should not be any prior art for that particular patent which you want to claim that as your intellectual property. Then industrial application, it can be used as a utility patent. So what cannot be patented? So just here I want to mention about the from the time of application to the time of grant, you have around the 1 to 81. 81 sections are involved in the first phase. So that is called patent prosecution period. When you are going for a patent application, then when you are getting granted that particular. So this granting is going to take around 3 to 6 years in Indian norms and Indian functionaries, the timeline. So on average, 3 to 6 years it will take, depends upon the different applications, depends upon what is your idea, like that it will go. So around 81 sections are dealing with between the time of application and your time of grant. Then from time of grant to the time of expiry, there is going to be around 82 to 160. So totally the Patent Act is going to have around 160 sections. So before that 161 and 162 now it has been omitted because it is going to be the design. It was there in the Design Act of 1911. It has been not much used in that this. So around 1 to 160 sections are dealing in this particular Patent Act. So in that first 81 sections will be dealing between the period of time of application and time of grant. So in that, just a few example of the section 3A is going to be, so the Novartis case, as they have mentioned in the by the previous speaker, it is one of the landmark case in India regarding the Patent Act. So it is dealing with the section 3D, where they want to claim that as the beta crystalline product as a new product. Instead, the imatinib mesylate. So that is the anti-cancer drug which has been used. They have filed a patent for its beta crystalline form. So it's a different form of the same drug. So the 3D is the section which is dealing with that. It cannot be patented. So that's how they lost the case after fighting in the High Court, Supreme Court over 7 years of a period they have fought. Then it has been rejected by all the levels by as per the section 3D. So after that, in Novartis case, the section 3D has been came into a limelight, and it has been revised also in the provisions that has been incorporated. So if you look at few example, what cannot be patented, like example, machine that give more than 100% performance. So the 100% is nothing but the performance can be of a maximum limit is 100%. You cannot claim the machine is going to provide 200% performance. So it doesn't have any logic, like frivolous invention, contrary to the established natural law. Then perpetuous machines. Then section 3B deals with the commercial exploitation, contrary public order or model. Like if gambling has been prohibited by the public order by our government, then you cannot go for a gambling machine. Then device for house breaking, which is going to break your rule of law. So like this, it cannot contrary to the public order or morality. Then section B deals with causes prejudice to health or human, like biological warfare material or a device, weapons of mass destruction, the Terminator gene technology, then embryonic stem cells. So these are some of the commercial exploitation of a primary use of invention can cause serious prejudice. So like here, even during our COVID time, there has been so many controversial discussion about who has invented, what is the way that particular biological terrorism is happening. The virus has been become the biosafety leakage. So like this, there is so many controversial. So these all things comes into this kind of a WTO trade organization and protection, how your country can be protected against the different controversial things like terminated. So already it has been, it cannot be patented. So these sort of a biological warfare. So then there is so many things which cannot be patented in section 3 and 4 of the Patent Act. Certainly, so these most of the things has been detailed by the previous speaker, like frivolous invention, invention used for public order, discovery of scientific principle or a formulation, discovery of a living or non-living substances in nature, discovery of a new property or a new use of a known substance, like how we are mixing something, admixtures cannot be as a patent. Then arrangement, rearrangement, or duplication of the known devices. We are having a mobile phone, simply rearranging the devices in some manner or duplicating the same device, you cannot go for a patent, because technological innovations are having becoming more number of patents in the recent last 2 decades, we can mention. Then method of agriculture or horticulture, then medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings. So any process in these sections, because if you are looking at any surgical procedure, it is going to be based on the case-based surgical procedure. There is going to be a small changes is going to happen. But medical devices can be patented. So that is what. So here the process patent cannot happen, but the product patent can happen when you're going for some kind of a medical devices, or if you're using a surgical blades, it can be patented. So like that, there is a difference between what can be patented and what cannot be patented. So these are some of the things which cannot be patented, which all mentioned under section 3 and section 4. So what are the crucial points before starting the patent filing procedure? If you have an idea, you think that that idea can be patented and it can be protected, then you have to look at these 4 factors. One is non-obviousness, should not be a prior art, should not be there. Then what is the non-patentable subject matter, whether it is coming under non-patentable or it is coming under patentable subject matter, that you have to look into. Then what is the uniqueness of your idea or process or the solution, what you're thinking as your intellectual idea, then should be used in the industry. It should have some kind of a industrial application. So these 4 crucial points need to be there before you go for a patent filing. So the non-obviousness, the invention must be technically advanced compared to the present knowledge and makes the innovation non-obvious to a separate skilled in the art. Then non-patentable subject matter means the invention must not come under the non-patentable subject matter, like section 3 and section 4, it should not come. Like the Novartis case, how it has been got rejected because of this non-patentable subject matter, because it is just another form of the same. There is no new invention. Then uniqueness, the invention should not be predictable by the publication or shouldn't be used in the nation before the precedence date of the patent filing procedure. So that kind of uniqueness, it should not be predictable. So that before the publication, then should be used in the industry. It should have the industrial application. So the step-by-step patent filing procedure in India, if you look at, before you are going for a patent, you have to go for a patent search. So the patent search can be done in the IP web pages, which is the governmental web pages, where you can search what are the existing patent and look for the prior art, what is about your idea, whether you can go for that patent or not. Then filing of a patent application will become the second stage. Then publication. Once you file, it will be published in your manuscript. In the drafts, it will be gazette, it will be published. Then the particular published after a time period, the inspection will take place. Then you look for any objection, whether it's a pre-grant objection or post-grant objection will come into picture. Then only it will be granted. So it is a 6 steps are involved. Then what is the patent process? If you look at the publication, from the publication, then you will call for the examination, request the examiners to come. Then you will get the report from the examination. Then you respond to that particular examination report. Then you amend that response in your patent. Then whether it is compiled with your compliance is improved in your patent, then you will get a grant. Then once you get a grant, then you have a 20 years period after the grant. So the overall period is 20 years. The grant is going to be renewed year by year. You have to pay the fees. If you are losing, not avoiding, missing the fees, then it will not be renewed. The patent will get rejected during that phase. So this is the different steps patent filing procedure in India. If you look at the first thing is you can go for a provisional or complete patent application. So generally, if you are a research student or if you are a faculty member or a team working in any project, you think that, so this particular idea already 20 to 30% of the initial data you got, whatever the path you are traveling will give a good product which can be patented, means then you can pushing those information in the provisional application, then you can go for filing. So after provisional application, once it's filed, you have around 12 months of time to put your complete application in place. So the 12 months you will be protected by keeping your provisional application for your idea. So you can go for a provisional or complete. So there is 2 ways of applying it. Then publication of application promptly after 18 months from your provisional draft. Then request for the examination will take place within 48 months after your publication of applications in your gazette. Then once you requested, the examination issue the first evaluation report. Then is there any third party representation is there to go for a post objection or pre-grant objection? All objection to be complete within 12 months. So this 12 months is the period where you are going to get your objections. Then the grant of patent will happen. Then after the grant of patent, the decision of controller will take 12 months. Is there any post-grant opposition is coming in place or not? After the waiting period, then the decision of the controller will go to the appellate body. So he is going to revocate or amend, depends upon the what is the opposition is appealing. So this is the overall flow of the patent application, how we are going to do it. Just we look at briefly what are the different steps. So there are in India, we have 4 patent office in Mumbai, Chennai, and Delhi and Kolkata. Then provisional application comprise. So as I mentioned, you are working on an idea, you are getting a very slow progress and you are thinking that it can be going to be a good idea for a patent. Then you can mention the title of invention and idea of invention, go for a provisional application. Then complete application should contain all the title, abstract, the complete description of your idea, what is it is going to be used, what are your claims in that, what is the scope of that particular utility, then diagrams and claims. Everything has to be incorporated in your complete application. If provisional application is filed, then within 12 months, as I mentioned, the complete application has to be filed. If patent is successfully granted, then the date of patent will be the date of filing of your provisional. So you are going to get the 12 months time period to protect your idea. So it is securing the filing date, 12 months of time to file complete specification with low cost fees. If the invention is ready, then complete application, you can go for it directly file. So what are the different types of a patent application? If you look at, you have a provisional application, then non-provisional application. So non-provisional application is nothing but ordinary application, which is going to be the conventional application. Or else if you are going for a PCT, so the Patent Cooperation Treaty, which is going to be the international application, where you are going to place only one application in your Indian office claiming as an international IA, international application, which can be used in all the countries which has the signatory of your PCT by IPTO. So then national application, application for patent of addition and divisional application. So there are two patents. Once you file an application as a complete application and you have mentioned around 5 claims. So in that 5 claims, 5 different utilities, you want to divide that particular 3 and 2 differently. After applying that, then you go for a divisional application. From the parent application, you divide some of the claims and you go for a another patent. So this is the divisional. Additional application means when your patent is granted. So from the granted patent, it is going to be the continued use or continuation of that particular parent idea. Then it is going to be a patent of addition. So what is the procedure for getting grant of patent in India? So there are around 11 steps. File a patent in Indian Patent Office, formality check, publication, you request for the examination, you receive the FER, then your response from the applicant, pre-grant opposition, examination of pre-grant opposition, consider a pre-grant opposition, then grant a patent, post-grant opposition. So if you look at what is obtaining a patent, this is filing an application. So the application of the patent can be filed with one of the patent offices. As I mentioned, there are 4 patent offices in India, which is near to your residence or office. You can file that particular patent in that office. Then depends upon the people who want to look at the function of a different office, then they may file that particular office. The pay by along with the payment of the required fees. All the information you can get it directly from the ipindia.nic.in. All the guidelines for application also available on that particular web page. So that is the first step. Then what is formality check? Once you file an application, the examiner will check the formal requirements, whether the accepting the application, the fees is right. It's like a clerical checking. This is done immediately after your application has been filed in the office. Then issue of application. So once that has been checked, then the application number will be issued to you and the cash receipt for that particular registration fee or application fee. This is done on the same day. In the case of receipt of application, if you're sending through post, then it will take around 2 to 3 days for the formality check. Then when they're going to publish your patent, application is kept secret for 18 months from the date of filing. Once you have put the application, after 18 months, it will be stay in the office as a secret. Then in the 19th month, the application is published in the official journal. This journal is made available on the website weekly. So if you want to go for the publication before that particular 18 months period, because why you want some kind of request prior publication means sometimes you may feel that other competitors is going to file the similar kind of a patent or idea. Then you may be asked to go for a publication earlier phase. So the application is published within 1 month of the request. So once you go for a request, they will publish that in the, because once you are disclosing your idea through the publication, once disclosed, then only it is going to become your application. The time the other person cannot intervene and go for a similar kind of a idea as a patent application. Then you call for request for the examination. So you have to request for the examination can be made either by applicant or by through the patent attorney. The period of 48 months from the date of filing is available for making a request. So you have around 48 months for making a request for examination. So this 48 months is going to be a time period where you are going to work on all the process. When they come for the examination, that has to be clearly mentioned so that you can avoid the opposition or you can avoid some kind of a shortages or some kind of drafting errors in your patent. So the examination will take place within a month from the date of request. Once you have requested, within a month, the examination will take place with respect to whether the claimed invention is not prohibited for grant of patent. Whatever your claimed invention, it is not prohibited under the Patent Act and patent rules, whether the invention meets the criteria of patentability. So these are the two things they will check as an examination process. So once the examination process is over, within 1 to 3 months period, they will submit the report to that particular controller of the appellate body. So the 1 month time available to the controller to vet the examiners. So he will undergo the vetting process of the examiner's report. Then the FER, the first examination report containing the gist of the objections, is issued within 6 months from the date of filing of request. So within 6 months, you will receive what is the examination report. Then what is your response from the applicant side? 12 months, you will have the time from the date of issue of FER for your to meet out the objection which has been came in FER. If the objections are made, grant of patent is approved by the controller within period of 1 month. Then pre-grant opposition. Once your grant is approved, so after publication, opposition can be filed within a period of 6 months. If you want to change or if you want to go away, if any other people want to oppose it, it can be within the 6 months after the grant. Then opportunity of hearing of the opponent is also available. So you will be given an opportunity for the opponent so that he can be heard in the appellate body or in the patent office. Then examination of a pre-grant opposition. Once if any pre-grant opposition is coming, that has to undergo the examination process by the opposition is sent to the applicant. The complete documents of the opposition will be sent to the applicant, and it will take 3 months allowed for the receipt of responses. Then considering of pre-grant opposition, so they will examine what are the documents has been submitted during hearing. Controller may either reject or accept the opposition to modify, reject the patent application. So anyway, it can go, it depends upon the controller. After checking, it is like just like a legal case which is going to happen in your patent office itself. This is to be done within a period of 1 month from date of completion of opposition proceedings. So then the grant of patent, after the pre-grant opposition, a certificate of patent will be issued within 7 days. Grant of patent is published in the official journal. Then the renewal fees has to be paid within 3 plus 6 months from date of recording in the register. Then there is no fees for first and second year. Renewal fees on yearly basis is required to be paid for 3rd to 20th for keeping the patent in force, because it is a complete 20 year. So from the 3rd year till the 20 year, the yearly basis, the renewal fees has to be paid. The renewal fees will be mentioned in the section 1 of the table 1. So which is going to be different, depends upon the patent, how many claims. So every individual patent will have a different set of renewal fees. Delay up to 6 months from a due date permissible on payment for fee for extension of time. Patent lapses if renewal fee is not paid within the prescribed period. So this is the way. So then this is the procedure for getting a patent in foreign countries. Instead, so here just I want to mention about the method of applying a patent in many countries using only one application. As previously I mentioned, whichever the country under the Patent Cooperation Treaty, so you can go for an international application, but in your country, in your patent office, then that will be treated as an international application, and that particular patent is granted means that can be applied all over the 173 countries, which is a signatory of your PCT. So that is how you can get the foreign country patents. So just to conclude this particular patent process, intellectual property has become more significant these days. The rapid globalization after 1990s, the globalization has been taken into place. So it is possible and easy to file patents in any country. So that is one advantage. India is taking substantial efforts to protect the invention through the Indian Patent Act 1970. This act was amended many times to provide more protection to the invention and to give more financial benefits to the inventors. So these are the evaluations are keep on taking place in changing the acts and changing the rules. So just look at the other side, how we are doing as India how many patents we have. The total patent application, direct and PCT national patent entries, if you look at till the database from February 2020. So from over 1980 to 2020, we have only around 2020, we have reached more than 55,000 patent applications. But if you look at the other side, the United States of America or China, they're grabbing the total number of patents which has been filed globally. United States is covering 48.3% and China is covering 48.7%. So the rest of the countries is here. The India is only having around 1.9, nearly 2% of the patent application. So this is where our statistical database, where we stand in the global community of filing patents and granting patents. So the patent application for top 10 offices, if you look at the last 2 years, 2019 and 20, the China is nearly placed around 1.5 million patent application, which is nearly increased 7%. But if you look at India, we have filed around 56,771. So as why I want to compare India and China means because we are population wise, we are similar. The second phase always by the US, which is only half of China. So this is the number of patents which has been filed in 2019 and how they have improvised it. So actually US has been a bit declined for 4% while compared to 19 and 20. It may be because of the pandemic years. So this is how we are having 1, 2, 3, 4, 5, 6. We are placed in 7th in filing number of patents in the year 2020. So China IP office received 1.5 million patent application, followed by US office, Japan, Republic of Korea. The top 10 offices accounted for 92% of the world in that. So these top 10 countries are playing around 92% of the total world property. So only the other 8 is rest of world other countries. So this one more statistics where patents granted per million population. If you look at India, it's really in a very declining. Per million population, we have only 6 patents. So it's a grave lower number while compared to the other countries. Then rate of patents granted with service application, it's up to 2016 data. So we have around, if you are filing 100 patents, only 18 patents are getting granted. So that is how the 18% only per million population. So this is the Indian data exclusively. If you look at what are the different application, what are the different segments our Indian patents are filed. So mostly the computer technology is holding 14.6%. Pharmaceuticals is holding around 13.3%. Then organic fine chemistry 13.9%. So the computer technology is booming in the recent years. This is the data for 1980 to 2020. So from the first itself, so this is all other patents, but the number of patents are very less in number while compared to. So generally, what is the problem? So this is the patent application filed by Indians, filed in India and filed abroad. So the Indians who file their patent in abroad, they get around 41.2% total of granting. But whatever the people filing in India, only 10% is getting granted. So there is a big difference because of the process, because of the examination authority, what we have been in India, how the process and how the particular person who is applying for a patent. So how easily they take up this patent which is filed in India. There is a lot of corrections because the experts say that the fees. So if you look at the fees paid to file a patent in India, so it is only 1,600 rupees a legal fees for patent application. Then all put together like patent attorney charges, then different timeline charges, it will become 50,000 to 1.5 lakhs approximately if you want to file a patent till it's getting granted. But if you are going for other countries, the minimum of 15 lakhs in Indian rupees you need to spend. So when somebody want to protect their rights, then weightage of by different countries also is going to play a matter. So they give that much importance. If they're paying 15 lakhs, that much importance they give in their drafting and their correction and the examination response. All these things will happen differently. That's why there is an increased number of patents is granted when filed abroad by the Indian. So this is the data, totally 10% we are getting granted in India, and other countries by Indians is around 41. So these are sources from World Intellectual Property Rights. So still in 2020, as it's a pandemic year, India falls on the 8th overall. We have around 9th position, while compared to China, US, Germany, Japan, South Korea, France, UK, followed by India. So this is what is the number of filings and number of grants? How is the percentage? If you look at the last from based on the Ministry of Commerce and Industry, from last around 10 years period. So the number of filings are 42, and only around 5,978 has been granted. So that is what, as I mentioned in this picture itself, from 2010 to 2020. So this is the number of percentages, 13.6 to 10. So average from lowest, if you take 5.5%, the highest if you take 14.8. So the average is 10.8. So similarly, in the patent filed in abroad, you have a minimum around 30% is getting granted. So that is the difference here you can find. And you can look at the number of patents also, what we are filing in 2022 recent. We have just filed 66,500 nearly applications, in that half. So now over the period, it is slowly increasing how the patent is getting granted in the India, because of after this 2005 amendment in the patent rules, the TRIPS agreement compliance 2005 is getting over. Then slowly there is so many rules and provisions in the Patent Act is getting revised. So it is overall, it is going to grow in that way. Yeah, this is the way. If you look at here from 2006, 2010, so it's in the increasing pace around 40,000 patents. So this is the data what has been reflecting here also. So if you look at the most top 25 companies, most new patents, in which technology they are going for patents in 2021, the IBM is holding the first place, which is the technology oriented. So generally, so in this top 25 companies, you can feel all the blue is technology. So mostly technology. Where we can find healthcare, only one company in healthcare which is having a most new patents in 2021. Only Johnson & Johnson is the only company in healthcare sector which ranked among the top 25 with the most new patents in 2021. So this is a picture which, as we all, the most of the people who are here, maybe from pharmaceutical background, so our healthcare background, where most of the technological patent and consumer cyclical is getting like Amazon and Toyota, then industries, Fujifilm, Hitachi. These are the very old companies which is still holding the number of patents. So this is one of the picture which we can take it for our thought on how we want to go further. So with these slides, I want to conclude. There are so many initiatives has been taken by our Tamil Nadu government and the Indian government for improving the number of patents. And there are so many sensitization programs by our intellectual IP governmental agencies, and every college now pushing for entrepreneurship development and going for a patent of a small project. So just a brief picture in Tamil Nadu, if you look at around 3 lakhs engineering students are coming out every year. Everybody is going to do some kind of a project in their final year. If that particular, only around 10% of that particular projects can be made into a patent, then our data may not be only 60,000 patent application in a year. So it can be going in a very huge numbers. So that is the way forward, how we have to look at, and we have to work along with the different government agencies, and we have to look for different incubators and the patent attorneys whom we can work, and how a small idea can be pushed into the patenting level. These all because one more problem is the percentage of GDP what every country is spending on the research and development. So only in India, we are spending 0.7 to 1% of the GDP to the research and development. While going for China, they are spending around 3.5% of the GDP to their research and development. In US, if you're looking at nearly 2.8 to 3% of their GDP, they are putting it in the research. And that is one big reason why the number of patents are deferred while compared to those countries. Still, we can take our part, we can play our part to have a more number of patents in the coming years. Thank you all.
Thank you, Dr. Habibur Rahman, sir,
for
your valuable ideas. We have received a lot of information from your presentation, sir, like what we can patent, what cannot be patented, steps in patent filing, and different types of applications, and for patent applications and publication procedures, examinations, everything we received a lot of information. Thank you for your presentation. Now we will go ahead for some time for question session, sir. So in the chat box, till now there is no questions. I think everybody understand about. So well explained, sir.
Thank you. Thank you so
Few
much.
minutes we will wait for questions, sir. If anybody is asking. Audience, please, if you need to ask any questions, please raise your questions. So I think, sir, no questions, sir.
Yeah, I think
No,
there is no question.
no questions, sir. So with this, we will conclude this session.
Yes.
Once again, I thank you very much, sir.
Yeah, thank you very much, madam, for providing the opportunity to share my a little bit idea about the patent. So I look forward if participants, if you have any, especially from Tamil Nadu, if you have any patenting idea, if you look for any patent attorney, so you can be in touch with me where our small ideas can be taken to the next level through our entrepreneurship development cell. And we have we are trying to create that particular culture in the higher education institution where the people have to look for the project so that it can be lead to not only publication, it has to be led to the path of patenting. So this is the note I want to give out to all the participants. If you have any doubts and other things, you can be in touch with me through the email and phone calls also. Thank you, ma'am, for providing this wonderful opportunity to share some of my thoughts. Thank you so much.
Thank you, sir. So once again, thank you all the participants, and we appreciate you all being here. And this is the session for lunch break. This is the lunch break. We will start the next session, session 3 at 2 p.m. sharply. So I request all the participants to join the same link at 2 o'clock. Thank you.